Most of the time, it's easy to figure out when a contract is made. You walk into a grocery store, pick up a gallon of milk labeled $2, then give $2 to the cashier. There's clearly been an offer, an acceptance, and consideration tendered. The store now has money, and you now have some milk. But sometimes contracts aren't entered into so clearly. Especially when buying something like land, the parties often talk or exchange letters. They ask questions, get answers, and work up to the point that someone makes an offer. But how can we tell when negotiations have culminated in a real offer? The California courts considered that question in Lonergan versus Scolnick. Albert Scolnick owned a 40-acre plot of land. In March 1952, he placed an ad in a Los Angeles newspaper offering it for sale. The ad didn't mention a price. Joseph Lonergan inquired about the land, leading to an exchange of letters. They discussed the land's location, Scolnick's minimum price of $2,500, and considered a bank for the role of escrow agent. On April 8th, Scolnick wrote to Lonergan saying in part, quote, "If you are really interested, you will have to decide fast, as I expect to have a buyer in the next week or so," unquote. On April 12th, Scolnick sold the land to someone else for $2,500. But Lonergan didn't receive Scolnick's April 8th letter until April 14th. And on April 15th, Lonergan wrote to Scolnick agreeing to buy the land for $2,500 pursuant to the escrow terms previously discussed by letter. Lonergan opened an escrow account on April 17th. Lonergan was ready to pay the price and otherwise carry out his part of the bargain. When he found out the land was already going to somebody else, Lonergan sued Scolnick, seeking an order compelling Scolnick to sell the land to Lonergan instead. The trial court ruled that Scolnick's April 8th letter constituted an offer, conditioned on Lonergan's prompt acceptance. Since Lonergan took more than a week to respond, the trial court held that Scolnick's offer hadn't been timely accepted, so no contract existed. The court ruled for Scolnick, and Lonergan appealed.